Many of us must have read about wars in the books, or could have even witnessed an armed conflict in the past. There is a popular saying that all is fair in love and war. Whether all is fair in love is not the subject of this episode. However, contrary to what you think, not all is fair in war. There are particular rules and laws that govern war activities and must be respected whenever there is an armed conflict. That is the purpose of law of wars, or properly so called International Humanitarian Law, which is the subject of this episode. I am Abolade Akikumi. Welcome to the Insights Legal. The law of war, or international humanitarian law, refers to the body of rules that apply during wartime or armed conflicts. Contrary to what we think, warring parties in a conflict are not free to do whatever they wish. There is a set of minimum standards that must be complied with during armed conflicts. There are quite a number of international treaties that govern wars and armed conflicts. The most popular international treaties that govern armed conflicts are the 4 Geneva Conventions. The 4 Geneva Conventions are a set of international treaties that govern armed conflicts. They were concluded in Geneva between 1864 and 1949. They make provisions for amelioration of wounded people on the field, sea, prisoners and civilian people generally in times of war. There are other additional protocols to these particular treaties. The Red Cross was instrumental to the development of the treaties. The founder, Henry Dunant, is reckoned for initiating international negotiations that produced the 1864 Convention. The first 11 articles of the 4 conventions are largely the same. They are often popularly called Common Article 1, Common Article 2, and so on because their provisions are largely similar. They make provisions for issues like respect and application of the convention, derogations, among several others. The first Geneva Convention has 64 articles. It makes provisions for the amelioration of the wounded and sick among members of the armed forces that are on the field during armed conflicts. Article 13 stipulates that the convention applies to people who participate in the war, either directly or indirectly. It provides that medical facilities shall not be attacked even if they belong to the adverse party. It makes provisions for detention and releasing personnel of the adverse party that are caught. It makes other provisions as to how to undo wounded members of the armed forces of the adverse party. The Second Geneva Convention has similar provisions to the first, only that it governs handling the wounded and sick members of the armed forces that are shipwrecked at sea. It makes provisions as to how to undo hospital ships and medical transport, among others. The Third Geneva Convention makes provisions as to how prisoners of war are to be treated when captured. It defines who a prisoner of war is. It provides that the capturing state is responsible for the prisoners and they must be treated humanely and with respect. The treaty also provides for questioning of prisoners and how their properties are to be handled, among others. The Fourth Geneva Convention makes provisions generally for how civilians are to be catered for right from the outset of the conflict. It provides that protected people are not capable of renouncing the rights given to them by the convention, among other provisions. Then you may ask, what would happen if the rules of international humanitarian law are breached? What happens is that people who breach those rules will be prosecuted for their crimes. They could be prosecuted before the International Criminal Court. The International Criminal Court is an international court before whom war criminals are prosecuted. It is an establishment of the Rome Statutes and has jurisdiction in 4 instances. The International Criminal Court has a prosecutor who brings cases before the court. It is also important to note that unlike the International Court of Justice, the International Criminal Court is not an organ of the United Nations. There are other international criminal tribunals before whom war criminals are prosecuted. Such tribunals include the International Criminal Tribunal for the former Yugoslavia and the International Criminal Tribunal for Rwanda. It is important to note that there is a difference between international humanitarian law and human rights law. Humanitarian law, which is the law of war, applies in wartime or during armed conflicts, whereas human rights law applies at all times and may be suspended partially when necessary, be it during war or peacetime. Thank you so much for watching. Please make your comments below and subscribe to this channel.